S14G1767, the State v. Gary Frost. Emily Keener for appellant, George Creel for appellee.
Take a seat when ready. I can't let you take that to the podium though, because we had somebody spill some water on that thing, shorted out a couple of weeks ago.
I would not want to destroy the court's technology.
You can still use it from your table though, if you'd like.
Okay, thank you very much. I'd like to go ahead and reserve 3 minutes, if I may, for rebuttal. May it please the court. Good morning. My name is Emily Keener. With me this morning at council table are Barry Morgan, Solicitor General for Cobb County, and Melissa Tatum, Assistant Solicitor General. Your Honors, in the case below, the Court of Appeals erred by finding that prior convictions for driving under the influence were inadmissible under 24-4-417A1 in a subsequent prosecution for DUI. They erred in 3 ways. First, by failing to follow the rules of statutory construction and ignoring the plain language of the statute. Second, by frustrating the legislative intent in enacting a statute that specifically allows for the admission of this evidence. And third, by holding that prior DUIs are not relevant under 404B to show knowledge or intent. 24-4-417, which I'll refer to as 417 throughout my argument, was enacted as part of the revamp of the Evidence Code. It went into effect January 1st, 2013. While the majority of the new evidence code tracks the federal rules of evidence, 417 is a provision that's unique to Georgia. And in reaching the decision that it did, the Court of Appeals overlooked that uniqueness and rendered Code Section 14 practically meaningless. That's why this case is so important. We're asking that this honorable court reverse the Court of Appeals, find that the trial court did not abuse its discretion in admitting the prior bad acts herein, and we're also asking that the court outline the proper application of 417 to guide trial courts and parties in the future. The first way that the Court of Appeals erred was by failing to follow the rules of statutory construction and ignoring the plain language of the statute. It's an elementary principle of statutory construction that courts are to construe a statute according to its terms, give words their plain and ordinary meaning, avoid a construction that makes language mere surplusage, all while seeking to effectuate the intention of the legislature. State versus Mussman, 289, Georgia 586. The starting point for statutory construction is with the literal text. And where the literal text of a statute is plain and does not lead to absurd or impracticable consequences, we're to apply the statute as written without further inquiry. That's from Hill versus State, Georgia Appeals, 531. The Court of Appeals held that the prior bad acts under 417A1 are relevant to prove knowledge, plan, or absence of mistake or accident if and only if a defendant took and failed the state-administered test in the prior DUI and the defendant refused the test in the subject case, and if the defendant at trial attempts to suggest that he didn't take the test because he did not understand it, or he did not know he could take such a test, or that he would never take such a test. As you see here on the board, I've put up 417. You will not find that language in this code section. This is a conditional relevance standard that's not supported by the text, and interpreting it this way required the Court of Appeals to resort to a subtle or forced construction that limits the statute's operation. This is also, aside from being a violation of statutory construction, problematic and illogical for a couple of reasons. First, the requirement that a defendant has to have taken the state test in a prior treats defendants differently. The defendant who complied with the implied consent law and took the state test in a prior is later at a disadvantage when that later DUI, or when at a later DUI when that prior comes in. On the other hand, a defendant who is savvy enough to have refused the test in, let's say, his 5 prior DUIs is rewarded because those prior convictions don't come in. That's punishing the defendant who cooperated with the state test and rewarding the one who did not. And that construction does not make sense. Secondly, there's no basis in the text for the requirement that was put into place by the Court of Appeals. The Court of Appeals relied upon Professor Paul Milich from Georgia State University. And with all due respect to Professor Milich, the opinion that there had to have been a test and a prior action, and that there must then be affirmative steps by the defendant to make that prior relevant, is confusing prior bad act evidence with impeachment evidence. Professor Milich's support for the proposition that the Court of Appeals adopted comes from the case of Long versus State, 185 Georgia Appeals 277. And that was a case that involved the use of 2 prior DUI arrests for impeachment purposes. The evidence came in not as a prior bad act, but it was because the defendant took the stand and opened the door to the evidence by saying he wasn't familiar with the terms of the implied consent warning. That kind of evidence, impeachment by contradiction, was always admissible in Georgia, and it remains so under the new evidence code in 24-607. The statute that we're talking about here today, 417, is in the 400s with case-in-chief evidence. It's not in 600 with impeachment. Professor Milich's reading renders 417 completely superfluous. Most importantly, though, this rewriting of the statute, this judicial construction, is not only unwarranted, but it's prohibited. And there's a litany of case law that supports that. Glover versus State, 272 Georgia 639, City of Jessup versus Bennett, 226 Georgia 606. If the General Assembly had intended to include this language, they know how to do so, and they could have, and they did not. Secondly, the Court of Appeals erred by frustrating the legislative intent behind the enactment of this statute, which was designed to allow the admission of this evidence.
Mr. Senator, can I ask you, is the gravamen in your argument simply the wording of the statute itself? Is that your basic argument?
That's our basic argument. It's as simple as that. That when you read,
Construction.
yes, that the Court of Appeals in this decision added language that was not there to begin with and should not have done so. If we even needed to get to the legislative intent behind this statute, we would see that the General Assembly deemed DUIs important enough to give them their own specific statute for the admission of this evidence in certain situations. There are only 2 other kinds of crimes in Georgia that are important enough to have their own specific statutes regarding the admissibility of prior bad act evidence: sexual assaults and child molestation. That's in 24-4, 413, and 414, and then there's a related provision in 415. Sexual assaults, child molestations, and DUIs are things that the General Assembly realizes don't happen just once, and there's a strong policy argument for protecting the public from these crimes.
You still have to show relevance. I mean, that's what it all boils down to, relevance to either proof of knowledge, plan, or absence of mistake or accident.
That's correct.
And I understand your argument there to be based on the doctrine of chances, that if somebody has committed a similar DUI before, then it's, and thus there's evidence that the person drove voluntarily in a less safe way, and after consuming alcohol, it's more likely they did it again.
That's correct.
What would you say, and I understand that's what the 2 priors are here, but what would you say if somebody is on trial for a DUI per se, and their prior was for a DUI less safe?
I would say that the state could still show knowledge, plan, absence of mistake or accident. It's all going to be very fact specific. And the thing that I think the Court of Appeals overlooked here is that knowledge in a DUI situation is not only knowledge not to take the state test. It's not, oops, I learned my lesson, I'm not going to do that again. But it's going through the process of a DUI investigation. It's learning what kind of questions the officer is going to ask. It's knowing that, this last time when I had those 4 martinis at dinner and then went through these field sobriety evaluations, I didn't do well on the physical dexterity, the walk and turn, and the 1-leg stand. And so next time I'm not going to do that. And so limiting it to just knowledge not to take the state test is really narrowing it down too far. There's a broad base of knowledge that could be learned from any prior DUI into a subsequent.
That's a somewhat odd view of knowledge, because normally the knowledge absence, they have to do with material facts in the case. and it would lead to a lot of very specific views of how does this relate to something in the actual investigation. I mean, my understanding of the argument is again, if somebody commits a set of acts that are, if they're accused for a set of acts that are criminal, and they've done that same set of acts before, it makes it more likely that whatever they did was the process of voluntary action, not accident or mistake or lack of knowledge.
That's correct.
So if somebody previously had, is on trial for having, 0.10 blood alcohol content, and previously was convicted of just driving erratically after they drank alcohol, what's the similarity there?
Well, I think, and this gets into the 404B argument. This court heard the case of Jones versus State on January 5th. That was S14G 1061. And I think the answer to your question is to think of it as the act of DUI is a status plus an action. To convict for DUI, the state has to prove that the defendant voluntarily drove while in a less safe condition. And when a defendant's been convicted previously for DUI, he gains knowledge of how that legal standard applies to him because the physical condition that he was in previously was found to satisfy the condition of being less safe. And when the defendant takes steps in a subsequent DUI to withhold from law enforcement information about that condition, it suggests an awareness or a knowledge that he believes himself to be in that condition again. And our argument is that a defendant's own belief that he's in a less safe condition when he's been stopped by law enforcement is directly relevant to the question of whether he's in that condition again, and in circumstantial evidence of the existence of that condition or element.
Again, though, what if his, it's not this case, but what if the current case is a DUI per se, and the prior case was a less safe? So that, the defendant at some point drank alcohol and drove erratically, but now you're accusing him simply of having too much alcohol in his blood. How are the two cases similar? Because I understand the state's argument to be basically to go back to the prior law and say, any DUI, no matter what the circumstances, DUI less safe, DUI per se, it all comes in automatically.
Under the old law. That
Under
was
the old law,
under
and
the
I
old.
understand you arguing under the current law as long as
No.
you have one of these, the accused refuses a test, then it automatically comes in.
Not automatically. When you look at the statute, we do have the requirement of relevance, for one thing. And the standard that should be applied here is the definition of relevance that's found in 401, not the one that was applied by the Court of Appeals in the Jones case. That was the Hoffer versus State standard, 192 Georgia Appeals 378. That was a different standard of materiality. The materiality standard, or excuse me, the relevance standard that we should use now under this new code section is one that's much broader. So there's that safeguard in the statute, and there's also that the evidence has to be relevant to prove knowledge, plan, or absence of mistake or accident. The state has to make up that logical, or excuse me, make together that logical connection from the prior DUI showing something in the current DUI to prove knowledge, plan, or absence of mistake or accident. That's a fact-specific inquiry that the trial court should be allowed to make, and it would be reviewed by an abuse of discretion standard. I've touched a little bit, I think I covered fairly well that the Court of Appeals intended for this evidence to come in. And the reason that we know that they intended that is because they wrote this code section 417. They permit the admission of this evidence. This statute only operates in relation to the general intent crime of DUI. And then it opens the door for the admission of this evidence under 404B, and that's in subsection C of the code section. The Court of Appeals erred by holding that prior DUIs aren't relevant under 404B to show knowledge or intent. And their reasoning for that was because DUI is a general intent crime. The holding that prior DUIs are not relevant under 404B to show knowledge or intent is not consistent with federal case law. And now why do we care about federal case law here? In House Bill 24, the General Assembly stated its intention to adopt a new evidence code that was modeled after the federal rules. They referenced decisions of the U.S. Supreme Court, the Circuit Courts of Appeal, and if there were conflicts within the circuits, they looked to the 11th Circuit. The 11th Circuit, and we would join in the Jones argument, but just to wade into that as much as I need to, the 11th Circuit has permitted the use of 404B, other act evidence, in general intent crimes. And there are several cases that I can refer the court to. U.S. versus Duran at 596 F. 3rd 1283, a 2010 case. That was a general intent crime where prior bad acts were allowed. U.S. versus Ospina, 823 F. 2nd 429, a 1987 case involving knowing possession of marijuana on board a vessel of the U.S. And then U.S. versus Jernigan at 341 F. 3rd 1273, 11th Circuit case, 2003. Felon in possession of a firearm. And in that case, the Jernigan case, the court said that the case law in this and other circuits establishes clearly the logical connection between a convicted felon's knowing possession of a firearm at one time and his knowledge that a firearm is present at a subsequent time, or put differently, that his possession at a subsequent time is not mistaken or accidental. This same reasoning can be applied in the general intent crime of DUI. Those are similar because you have a status and an action. It's the voluntary driving while being less safe. I explained a little bit what knowledge can be. Knowledge in a DUI context, whether it's under 417 or 404, can be knowledge of what the field sobriety evaluations entail. It can be how one performs on those evaluations. It can be, as in the Jones case, whether or not to engage in the alphabet evaluation. In that case, the defendant said to the officer, well, I never learned, no officer, I never learned how to say the alphabet without singing it. That made it directly relevant to bring in that prior where the defendant engaged in the alphabet evaluation. Here in this case, the Frost case, knowledge can be learning from your previous experiences that drinking after driving, being found in your car with a container of alcohol, being seen drinking out of it, can be something that would make the state's case more difficult to prove, especially in the face of a complete refusal like we have here. We ask this court to reverse the Court of Appeals and find that the trial court did not abuse its discretion in allowing in the evidence of prior bad acts in this case under 417. And we're asking the court to give us guidelines to clarify how to apply 417 going forward. U.S. versus Delgado at 56 F. 3rd 1357 outlines the three-part test used in the 11th Circuit for the admission of other crimes evidence. We would ask for a modified Delgado standard, which would include where there is a refusal under 417, if the state can show first that the evidence is relevant using the 401 definition for a proper enumerated purpose, knowledge, plan, absence of mistake or accident, and the trial court can determine by a preponderance of the evidence that a jury could determine, that the defendant committed the act, then the evidence shall be admissible. We don't necessarily think a 403 balancing test is required. Should the court decide to implement one here, the trial court engaged in that balancing test. Thank you.
Mr. Creel?
May it please the court. I'm George Creel. I represent Gary Frost. Let me just say before I start that it's both an honor and a privilege to appear before this esteemed court. And basically, our position in terms of the analysis is not that much different from the appellant in this case. We believe this is a simple case. We believe that the Court of Appeals got this case right, that it's a well-reasoned opinion. We believe that both the plain language and the legislative intent support the interpretation that was made by the Court of Appeals.
That's what I was trying to tell. You and the state both say basically it's a statutory construction case.
It's absolutely a statutory construction case. You know, the statute is on the monitors. Essentially, although unfortunately you can't see some of the coloring that I've added or attempted to add, but essentially, in this case, what we need to do is the court has to be guided by, there are Georgia statutes that govern statutory construction, and they're the general canons of statutory construction that govern the interpretation of these types of statutes. starting with OCGA 131, construction of statutes generally. The General Assembly has stated that the courts shall look diligently for the intention of the General Assembly, keeping in view at all times the old law, the evil, and the remedy. And it goes on to say that the ordinary signification shall be applied to all words, except words of art or words connected with a particular trade or subject matter, such as relevance, I think in this case, which shall have the signification attached to them by the experts in such trade or with reference to such subject matter. And in this case, absolutely, the old law and the evil is, of course, bent of mind and course of conduct. There have been courts all over the country that have commented, law review articles that have been written about the bent of mind and course of conduct, permissible purposes that were previously allowed in Georgia for similar transactions or what's now called other acts evidence. And this was one of the main concerns of the Judiciary Committee that was chaired by the Honorable Wendell Willard. And in the video that the state cites repeatedly in both their appellant brief and their amicus brief, I'd have to add that I had to answer to 2 briefs from the state of Georgia, not just one. They repeatedly reference that video, and I think they take some of the comments of the commentators out of context, specifically the head of the Solicitor General's Association, but I'll get to that in a minute. But essentially, the General Assembly essentially said the remedy in this situation is we need to bring in the federal rules of evidence as a model code for the Georgia evidence. And so what we have to do with that as our backdrop and with that in mind is we look at the court's canons of statutory construction that the Supreme Court and the Court of Appeals have analyzed and attributed in their opinions. And I would point that the very first and most foremost and basic was cited in Six Flags versus Cole, 248 Georgia 866, in which this court said that in the absence of words of limitation, words in a statute should be given their ordinary and everyday meaning. And additionally, this court in Morton versus Bell 264 Georgia 832, a 1995 case, held that this court has repeatedly adhered to the venerable principle of statutory construction that the express mention of one thing implies the exclusion of another, or the similar maxim that if some things of many are expressly mentioned, the inference is stronger that those omitted are intended to be excluded than if none had been mentioned at all.
Isn't the real question here what these words mean?
Absolutely.
In connection with the federal rules of evidence, which are what this rule and others are modeled on, although this rule is somewhat different, but the terms, at least relevance and relevance to accident or mistake or plan or knowledge, those are exactly the words in Federal Rule 404B, right?
Exactly.
And isn't it clear if you look at the federal case law and all of the major commentators on Federal Rule 404B that even in a general intent crime, which is what our so-called strict liability DUI crimes or general intent crimes, that evidence like a prior DUI of the same sort comes in under the doctrine of chances or the doctrine of objective improbability, that you have to show a defendant voluntarily drove after consuming alcohol in a left safe fashion, and the fact that the defendant had done that exact pattern of things before makes it more likely he did it again in a voluntary way. Voluntary is just another way of saying without accident or mistake.
I understand the doctrine of chances, but the issue here is where does the doctrine of chances apply? Is it knowledge, plan, absence of mistake or accident? And see, I think that's where the rub is.
The federal courts and the commentators have said it applies whenever you have a set of similar conduct, whether the intent is specific intent, general intent, whatever the intent, or voluntary intent. The fact that something happened before makes it more likely that it didn't happen again because of an accident or a coincidence or a mistake. And the cases use the term accident and mistake as corollaries of voluntary. If something is an accident or a mistake, it's not voluntary.
I understand what you're saying, but I would argue that the doctrine of chances doesn't apply under the permissible purposes enumerated here. That's my position. In fact, my position on 24-417 is that it essentially is a codification of a rebuttal standard in a DUI case. And that normally why a person refused would be immaterial and therefore not relevant. And the other issue here is the doctrine of chances, again, is getting very close to...
The evidence here, though, doesn't go to why they refused. The why they refused is to trigger this Rule 417 instead of just Rule 404. And 417 is mandatory. 404, the judge has discretion whether to admit or not. 417 says it shall be admitted. So the judge, if it qualifies, the judge can't say, well, it's marginal. So, and also explain how as a rebuttal provision, it would require the state to provide notice. What other area of evidence law requires the state to provide? Normally the rule is actually the opposite, that you don't have to provide discovery or notice for rebuttal evidence. So it'd be very strange to have what's a rebuttal rule with a notice requirement.
Let's see if I can find it in my notes. Essentially, if you look at 404B, and I'm desperately looking for the provision now, under the federal rules in the advisory committee notes, I believe it was the 1991 amendment to the 404B in federal court, where I guess Congress was responding to Huddleston, where there was an issue of whether the state had to provide notice. They actually legislated that into the federal rules and held that it didn't matter whether it was for impeachment or possible rebuttal. The state still, or the government in that case, still had to provide notice at a reasonable time or 10 days before trial. There's also, I believe there's also a federal 11th Circuit case maybe that addresses it. I just can't find it right now.
But that's under 404B, which is not, as you say, limited to rebuttal. I'm just trying to figure out why in a pure, if it's a pure rebuttal provision,
Here it is.
why you would have a notice requirement. How do you even know if the defendant is going to raise the issue? You'd have to provide the notice, I guess, in every case because you don't know if the defendant's going to raise it?
Yeah, absolutely. I think you do. And the case is U.S. versus Bradley, 644 F. 3rd, 1213, 11th Circuit, 2011. And it was a 404B case, but the 11th Circuit held that pretrial notice by the prosecution of any intended uses of prior crimes, wrongs, or acts of the accused, even for rebuttal. That was made very clear in that case. And let me just speak to the issue of the state arguing that 417, because it says shall, is mandatory. Well, if you look at subsection C, it also says shall. It says shall not be the exclusive means to both admit or to consider prior acts evidence. So, the way I read this statute, it's similar in a PI case. You have 3 mountains to climb. You have duty, you have breach, and you have damages. And in a prior acts case, you've got, if you're going under 417, which is a specific limited situation, then you have to first get through the gate of 417. And then you have to get through the gate of 404B, and then you have to get through the gate of 403. And the state's basically arguing the same. They're arguing out of both sides of their mouth. They're saying it shall be admitted if it meets the requirements of the statute, yet at the same time, we want to apply the Delgado standard. And we want to do the three-part test, but we want to forget about the third part, which says we have to do a balancing under 403. The real danger in these cases is that, if I can gather my thoughts here briefly. It was articulated by the DC Circuit Court of Appeals in United States versus Lavelle, 751 F. 2nd, 1266, where the court wrote, "The danger of prejudice stems from the possibility that evidence will be used by the jury primarily for the impermissible purpose of inferring guilt from a general defect in character, and the danger that the evidence will inflame the jury into reaching an impassioned and irrational verdict."
But that is the danger, and that's what 404B refers to as character evidence. But again, the case law, including the DC Circuit and the commentary, says the danger is dissimilar prior acts. The fact that the acts are very similar makes it more likely that it will happen again, and it happened voluntarily with the appropriate intent and knowledge. Character is proving that somebody committed a DUI because they were murder, or they committed a DUI because they have a prior for fraud, and so they're dishonest. And that, the roots of 404B in the federal case law and commentary, it's very clear that that's the danger. I don't understand how that danger applies when the prior acts are the identical acts.
Well, the danger applies in this situation because 417 is unique. It has no federal counterpart. And the issue here, as you stated before, is relevance. Such evidence is relevant to prove. And the problem is, if it's not relevant to prove one of those four permissible purposes, then what you're getting into is propensity evidence, propensity of criminal conduct. And the commentators have often said in these situations under 401 that, yes, it is an inclusive rule, but it stops being inclusive at the point of criminal propensity. And that's simply all the state is arguing in this case. Now, the other issue here...
When you say propensity, are you talking about the specific propensity to commit the acts at issue?
Yes.
Or the general propensity? Because the commentary in the case law says the concern is the general propensity.
Yeah, well, you're right. It is a
This
general...
person commits crimes, therefore they committed this crime. But all the commentary in case law says the fact that they committed this crime before, this similar crime to the new crime, makes it more likely, and that's an entirely appropriate thing for a jury to consider. And in fact, it defies common sense to not consider it. So that's my concern. What's your authority for saying that someone who commits a prior act of the same sort, that is made irrelevant, or that it goes to their general character?
Well,
do you have a case for that?
I don't have a case because this is a new statute and it's never been construed before, but
These words, relevance,
Yeah, but that goes to-
propensity, they're all federal words. What's your
that
best federal case?
I understand. I don't necessarily right off the bat have a federal case. I don't have the depth of experience in federal law that you do. But the issue is that we have to deal within the confines of 417. And maybe the flaw in our new evidence code was that we don't have advisory committee notes that the federal rules of evidence has. All we have in this case is the video from the March 9th Judiciary Committee meeting chaired by the Honorable Wendell Willard, where these issues were discussed by Professor Milich, who was on the advisory committee that formulated these rules, and in conjunction with the Judiciary Committee, negotiated this compromise. And that's where the legislative intent comes in, that the chairman in that case was very concerned, if you listen to the video, about this prior act information coming in, and had actually held up the solicitors and the DAs on the bent of mind argument. And Brian Fortner says outright, we gave up bent of mind. We gave it up in exchange for this 417. And 417 essentially was the compromise, and they said in particular cases, in refusal cases, Professor Milich said it, Mr. Fortner said it, we need to be able to go in and explain if the person says, I refused, for the because I didn't know, I could take a test, I didn't know what my rights were, that, well, no, you had a prior DUI, you took a test in that DUI, and now you're refusing and claiming you didn't know. That's relevant knowledge, which normally wouldn't be material, but it's made material by the defendant.
Counsel, why is a refusal admissible?
Why is a refusal admissible?
Right. Why is a refusal relevant? What does it show?
The mere presence of alcohol in the person's body.
But why logically does it show that?
I mean, because the General Assembly says it does. I mean, it doesn't really play in a less safe DUI. Taken alone, a refusal, you can draw no inference of impairment from a refusal, merely the presence of the prohibited substance. But in conjunction with other evidence, it may be construed for a finding of less safe DUI.
That's right. The jury can infer from a refusal. That much is clear from the case law. A jury can, they don't have to, but they can infer from a refusal the presence of alcohol. Why logically can they infer that from a refusal?
Well, I believe it's statutory that the only permissible inference is under 392 is the presence of a prohibited substance.
Let me suggest this
I'm
to
not
you. The
understanding.
reason the jury logically can infer that is because a refusal is at least evidence that the driver was conscious of the presence of alcohol, and that's why they refused.
Not necessarily. I mean, the exercise of a refusal is the exercise of a legal right. And so in some sense, are we going to use as similar transaction evidence the fact that someone exercised their Fifth Amendment right to remain silent, to not provide the state with evidence? Is that going to be, the doctrine of chances? Yes, there's an argument for that, but I think you run dangerously close into using someone's use of the legal process that they know about. Maybe they don't believe in the science behind the Intoxilizer 5000, which the state has found now is scientifically unreliable and is spending millions of dollars replacing.
Well, maybe so, but those are all issues for the jury. I mean, the reason the prosecution can bring in the refusal, the reason it is probative is because it is probative of the consciousness of the driver, that it's arguably probative of the consciousness of the driver of the presence of alcohol. And so if that's the case, I would suggest that in the event of a refusal, in a case involving a refusal, then any prior experience with DUI, whether less safe, whether per se, goes to knowledge, plan, or the absence of mistake or accident in refusing the test. Even if you refused every time before, and now you refused again, this is your fifth refusal, then it tends to show, does it not, that your refusal is not an accident this time. You refuse every time. It shows a plan.
Well, you can choose to interpret the statute that way, but you're rewriting the statute. You're legislating. And because the advisory committee was very explicit.
Well, the problem with the advisory committee, this and that, in the end, they didn't use any of the words that, that would change things. They used the federal words, right? I mean, in the end, what the people voted on and the governor signed into law was not a videotape. It wasn't Professor Milich's book or views. It was words used in the federal rules, right?
Well, I think that if there's some issue, and apparently there is, on how to interpret these words, you have to look at the video of the Judiciary Committee to find the legislative intent, because that's the only evidence there is. And you have to abide by it. Otherwise, you're legislating from the bench.
Thank you.
Thank you.
Any rebuttal?
Yes, thank you. Well, opposing counsel and I agree on one thing here, and that it's the plain and ordinary meaning of the statute. We don't need any advisory committee notes. We don't need a video of the committee hearing. There was no discussion on the floor when this was passed, so we take the language in the statute and we need to apply it as written. It's not a codification of a rebuttal standard. And the reason we know that is because we have first that separate impeachment statute, We have the 10-day requirement in 417B, the requirement that the state give notice ahead of time, and because there's an inclusion of the identity provision. The statute talks about the 3 different times that this prior bad act evidence comes in: refusal, insufficient sample, and an identity issue. It doesn't all boil down to the issue of a refusal. The evidence that's described in this code section in 417, that's subsection C, it's evidence of prior DUIs. And they include that because 417 is so specific, and it only applies in those 3 different categories. And then you can go to 404B if you need to. If your facts don't fit 417, you can go to 404B and meet those standards. And Justice Namias, that was the answer to your question that I was struggling to get to. If the case is a per se and the prior was a refusal, it doesn't come in under 417 at all unless it's an identity issue. But it could come in under 404B if it's relevant to an enumerated purpose there. 404B is, or if we consider both these statutes together, which I think we need to do, 404B is sort of at the top of the evidentiary funnel. 417 is at the bottom. It's narrow and it's specific and it's mandatory. And we ask that you find that the trial court did not abuse its discretion, reverse the Court of Appeals. Thank you very much.
On behalf of the court, let me thank both sides. We appreciate your presentation this morning. That'll help us decide the matter. We're going to take a 10-minute recess.